You're on Paul Baker.
I have Jovan Reed. Do you have a Paul Baker today?
Oh,
Oh,
that's
I'm
what
sorry.
says
That
next to
must
your
be.
name.
I apologize. I didn't change my name.
No worries.
I'll rename myself. I'm sorry.
No, you don't have to rename yourself. I just that's the reason I said that name. I got you.
Okay.
So you said you're on Javon Reed.
Yes.
Okay. Okay, so he's at the DDC. So as soon as they zoom in, we'll see if we can call your matter towards the top. They zoom into us. They haven't yet. So just as soon as I think they're still doing interviews. So as soon as they do, see if we can bring Mr. Reed towards the top. Okay.
Thank you, Your Honor. I'll log out and sign my name incorrectly.
No, you don't have to do that, counsel. Not at all. You're completely fine.
Thank you.
Don't worry.
All right. Thank you.
You're welcome. All right. Are you ready, counsel? And come on up, local. Good afternoon, both of you.
Good afternoon, Your Honor.
Thank you. Say your full name, ma'am. Thank you. Good afternoon, Ms. Trasco. You're here on case 250444725, People State of Michigan versus Alicia Brooke Trasco's appearance for the people.
Lisa Coyle, appearing on behalf of the people, Your Honor.
Thank you. Good afternoon, Ms. Coyle.
Your Honor, David Rudoy, P75169 on behalf of Alicia Trascos.
Thank you. Good afternoon to you. As to the arraignment, sir.
As to the arraignment, we would waive the formal reading and stand up and mute at this time, Your Honor.
Thank you. And you've advised your client of her constitutional rights, is that correct?
I did, Your Honor.
Or waive formal reading and her plea of not guilty. I'm scheduling a pretrial date via Zoom. You must attend on June 27th. That's at 8:30. Judge Bryant here at the 36th District Court. Understood, ma'am? Not guilty, please enter it on your behalf as to bond. Ms. Coyle.
Your Honor, the people are recommending a 10,000 personal, no driving without a valid driver's license, no alcohol during the pendency of this case. I do not see a criminal history, which would include anything for a OWI before this or after this. This occurred back in February of 24. I do see the intoxilizer was a 168 and a 167, so very high. So that's why I'm asking for those conditions with the 10,000 personal. Thank you.
Thank you. Response.
I'm sorry, what condition?
No alcohol, no driving without a license.
Oh, very good. Your Honor, I would ask for you to follow the recommendations from the people. Just a few notes. I would just note for Your Honor, this case did take a year before it was authorized. Due to some confusion about which court it would be in, I was retained over a year ago and under the belief that this would be in the Dearborn District Court. So that's the only reason she didn't turn herself in sooner. With that being said, Ms. Trascos has absolutely no criminal history of any kind. She's a graduate of Fowlerville High School. She was part of their marching band there. She attended Washtenaw Community College, eventually graduated from Bluegrass Community and Technical College. She currently works for Henry Ford Novi as a respiratory therapist, a job which she's held for 7 years. She's never missed a court date, never violated a court order, and has retained counsel. So for those reasons, I would ask for a personal bond. I'm not sure if it needs to be a $10,000 personal bond, but that's not an issue. And that would be it, Your Honor.
Thank you. Ms. Trascos, you've heard your counsel's advocated well on your behalf. You've surrendered yourself. You have no criminal history, capious or otherwise. I do have concerns, as the Ms. Coyles pointed out, that the allegations of the blood alcohol are over 100% the legal limit, and that is concerning. And given your lack of history surrendering yourself, I am going to follow both parties' recommendation in part that you'll be released on a $10,000 personal bond. You don't have to post any money. During this bond, there's no use of alcohol, absolutely no use of alcohol, and no driving of any vehicle unless you have a valid driver's license. Do you understand? Counsel or Ms. Trascos, do you have any questions on court date or bond conditions?
Is there any opportunity to move that court date, or will I need to get a citizen order?
You would need to speak with Judge Bryant.
Thank you very much. And
You're
what time did you get for that court date?
That's at 8:30.
It's at 8:30 on Zoom.
Yep.
Thank you very much, Your Honor.
You're welcome. Ms. Trascos, just have a seat. Officer Brown will get you some paperwork in a moment. Good to see you, counsel.
Good to see you as well. Good to see you, Lisa.
Nice to see you. Take care.
All right. We're just waiting on the DDC, everybody. Thank you. Ms. Carson, I just wanted to let you know that the DDC has still not joined us, so we're just waiting on them to join us, and we'll call your case.
Thank you, Your Honor.
Thank you for your patience. Traffic tickets. Come on. Did he post this bond by chance at 2,500, 10%? No, okay. Well, we're just gonna handle the traffic matters first.
Okay, I'll just stand next to him.
All right, thank you. All right, good afternoon, Mr. Nelson Jr. State your full name, please.
Robert Forrest Nelson Jr., sir.
Thank you. You're here for a couple of reasons. We're gonna hold off on the felony matter, but you have a misdemeanor allegation we can handle while we're waiting on Chief Judge McConicle. On this matter, sir, I'll recall warrant set aside case. You shall have a personal bond, no dollar amount. I'm scheduling a pretrial via Zoom, July 1st, 9 a.m. Judge Millhouse. Understood?
Yes, sir.
All right. As with any criminal matter, you have a right to remain silent. Anything you say orally or in writing can will be used against you in the court of law. You have the right to an attorney at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights?
Yes, sir.
This case Z 8092591 allegation against Robert Forrest Nelson Jr. took place on or about April 22nd, 2024, operating while intoxicated. First offense, city. Recall warrant set aside capious. So the misdemeanor carries up to a $500 fine and or 93 days in jail is a maximum fine and penalty. You have a personal bond on this matter, no dollar amount. During this bond, there's no use of alcohol, period, given the allegation, and no driving unless you have a valid driver's license. You understand?
Yes, sir.
Do you have any questions on this matter?
No, sir.
Okay, just, I have a seat. We'll get you paperwork on this matter. Don't leave until we handle your felony case, okay? All right, do you have any questions?
Judge, I've had a couple of paid attorneys and one, I'm on probation, so I can't drink or none of that.
Okay,
And I think the guy that represented me in that case, his name's Austin Gregory. My lady friend, he wanted a retainer of $300. We cashed after him $300, and the guy never returned my phone calls. The lawyer had before that, I paid him, and he retired and left the country.
you have a question? You're just letting me know that? I appreciate it. Do you have any questions?
No.
Okay.
Judge, can I have the court date? I'm gonna make sure he gets all his dates in order.
Yes, this one is July the 1st, 9 a.m. via Zoom, Judge Millhouse. Okay, just have a seat, Mr. Nelson Jr., and then we'll handle your felony matter in just a moment, okay?
Yes, sir.
We have them now. So I guess, we can call Chief. As soon as they come out. We have them.
Magistrate,
Yes, sir. Good afternoon.
do we only have one capious matter?
We have two, one on a walk-in, Robert Nelson, and then one at the DDC, Purvis Collins.
Okay, thank you.
Oh, you're welcome. Good afternoon, DDC. We have one capious with you, Purvis Collins. We're gonna wait on Chief. If we could have number 2 standing by. Javon Reed, if you could bring that gentleman first, number 9. We have retained counsel. After that, at your pleasure. Thank you.
Thank you.
Mr. Nelson, he'll be joining us shortly, and then you'll come up and handle your matter, okay? Thank you. Good afternoon, Mr. Reed. This is on case 2504548 People State of Michigan versus Javon Gino Reed, appearance for the people.
Events in P71917.
Thank you. For the defense, Ms. Carson.
Good afternoon, Your Honor. Stephanie Carson on behalf of Mr. Reed, P57096. We waive the formal reading of the information. Stand mute. My client has been advised of his constitutional rights.
Thank you, Ms. Carson. Good afternoon to you. Court waive formal reading under a plea of not guilty. Mr. Reed, I'm scheduling an in-person pretrial. You have to come down to the 36th District Court on Friday, June 27th, 9 a.m. Judge Austin Garrett, in person. Understood, Mr. Reed? Yes, sir. Not guilty, please enter on your behalf Esteban from the people.
Sorry, Your Honor, Lisa Coyle appearing on behalf of the people. Your Honor, I'm going to tell you, all day my computer has been freezing up, and so I can't tell if you guys can hear me or not. So I apologize. Okay. Good afternoon, Ms. Carson. Lisa Coyle appearing on behalf of the people. The people are asking. I understand this is a 1-year misdemeanor. The people are asking for a $25,000 cash surety bond, tether house arrest on this matter. The allegations are that Ms. Lattimore, the complainant, was jumped down by the defendant while she was caring for their child. Allegedly, he put both hands around her neck and was strangling her. Released her from the chokehold when the baby was underneath. He then continued to hit her in the head 6 or 7 times. I do note that he has a assaultive criminal history in which in 2006, he received a sentence of 6 to 10 plus 2 for a great bodily harm felony firearm. In 2015, I see a domestic violence on his record. I do note that is a different complainant in the 2015 case. That's in the same one as the case at bar today. He also did time for prisoner possession of a weapon, and his most recent case is the 2023 CCW. The people believe he is a danger to the complainant. There was a note in the APA file that he has been calling the complainant from jail. So for those reasons, Your Honor, the people believe he may be a danger to Ms. Lattimore. So I'm asking for that high cash surety bond, knowing, yes, it is a misdemeanor. This case could have been charged between a great bodily harm, strangulation, or a DV, or both. But the prosecutor used their discretion and charged the misdemeanor. But based on the allegations, based on his record, Your Honor, the people believe that a cash surety bond and a tether house arrest, if he's able to make that bond, is appropriate in this matter. And again, I apologize for my computer.
No, it's working fine. I'll let you know otherwise. Thank you, Ms. Coyle. Ms. Carson, response?
Your Honor, I understand Ms. Coyle's position. However, I have represented Mr. Reed before. He always shows up for court. And I do realize these are very serious allegations. They are allegations. I do know Ms. Lattimore. I do know she is in the process of separating from Mr. Reed. And I think that might have been the nature of the phone calls. They were trying to sever some things. But nevertheless, I'd ask the court to still give a nominal bond, maybe 15,000 cash surety, 10%.
You're asking for 15,000 cash surety?
10%, yes.
Okay. All right, Mr. Reed, these are very assaultive allegations. I've heard counsel as representation. He's represented you well this afternoon. Any employment status as relates to ability to post bonds also taken into consideration. Mr. Reed, where my concerns lie are the nature of these assaultive allegations coupled with your past criminal history. According to the people, and I see you have a great bodily harm conviction in the 06, a domestic violence conviction in 2015, and now we have a second offense domestic violence allegation, which it's alleged that while this young woman was caring for her child, you began strangling her with both hands around her neck, yelling, disrespecting, strangling while she was trying to care for the child. And then began, after releasing the chokehold, began hitting the complainant in the head 6 to 7 times with a bent hand. The court has concerns regarding the safety of this complaining witness. As stated, you have a number of previous assaultive convictions, and now we have an allegation that started with an argument, escalated into strangulation while she was caring for this young baby, and then proceeded and escalated to a point that you allegedly struck her in the head 6 to 7 times. In order to set an unaffordable cash bond, the court must find by clear and convincing evidence you are either a danger to a particular individual, the public, and or a flight risk. Here, given your criminal history, that this being a second offense domestic violence notice, the court finds there is a likelihood of conviction. And I do have concerns regarding the safety of Ms. Lattimore, given the escalation of the allegations of assault. Bond recommendation from the people was 25,000 cash surety. With the tether, your counsel asked for 15,000 cash surety, 10%. Given the concerns the court has, I'm setting bond at intentionally unaffordable at a $10,000 cash surety. During this bond, you are, and given these allegations, you are not to purchase or possess a firearm or any dangerous weapon. Absolutely no contact with the complaining witness, Ms. Lattimore, and that's no contact of any kind, orally and writing through a third party at her place of residency, employment, or through any forms of social media. Ms. Carson, is your client employed?
Yes, Your Honor, he is.
What are his work hours?
Mr. Reed, what are your work hours? I know he works
You're on mute.
days.
There we go.
Work from 9 in the morning to 4 in the morning.
9 in the morning to 4 in the morning?
So I do overtime Tuesday through Friday, and I have to pick the kids off.
19 hours a day?
That's what I can show you. I can show it to you too. I've been doing overtime, so.
I was going to give you work hours, like a standard work hour, but what I'm going to do is GPS tether with house arrest. 1 second, with house arrest, I'll allow work release when you provide employment to the tether unit, but you will have work release and no contact with Ms. Lattimore. And that's an unaffordable bond, counsel?
Yes, Your Honor.
I'm setting an unaffordable bond redetermination on June the 20th, Friday, 9 a.m. Chief Judge McConico. or someone in his stead. If you're unable to post that bond, Mr. Reed, you'll have a redetermination with council present on Friday, June 20th, where you'll have opportunity to re-argue bond. Ms. Carson or Mr. Reed, any questions on your court date or bond conditions?
No, thank you, Your Honor.
All right, you're all set. DDC, could we bring Robert, let's see, Purvis, number 2, Purvis Collins next, and then Robert Nelson come on up. We're ready, Chief, on Robert Nelson.
Okay, call it.
Thank you.
Your attention, please. This is
Your name, sir?
security. Please disregard any further alarms. The system is being worked on right now.
Thank
This
you.
is security. This is security. Please disregard any further alarms.
This is case 2505551. People say the Commissioner is Robert Nelson, also is Robert Frank Nelson,
This is
Robert Forrest
security.
Nelson Jr.
This is security. Please disregard any further alarms. We are conducting testing. Thank you.
Thank you. Appearances, please.
I found it first.
Thank you, Chief Magistrate Klepera. Good afternoon. Good afternoon, Chief Judge McConico. Always a privilege. Steve Benson for the people, P71917.
Good afternoon to everyone. Miguel Brito, on behalf of Mr. Nelson, who is appearing in person today to my right, P88379. Judge, my client's been advised of his constitutional rights, waives a formal reading of the complaint, stands to request a not guilty plea be entered on his behalf as to this matter.
Not guilty plea will be entered. What are the charges and what is the bond, Chief Magistrate?
These took place December 13th, 2022. Count 1 is weapon carrying concealed. Count 2, firearms possession by felon. Count 3, assault, resisting, obstruction. 4, 5 are both independently weapons, felony, firearm. The bond was set by Judge Jefferson May 23rd of 2025, 2,510%. It looks like Judge Jefferson underneath wrote witness present.
Okay, Mr. Prosecutor.
Judge, I got a defendant in the courtroom right now. I mean, he's on a capias, but yet he's appearing in person, you know, regarding a failure to appear on a case. You know, he's on probation right now for an R&O. He just got sentenced. Looks like March of this year, got 2 years out of Third Circuit. I mean, he has a decorated past. I got bank robbery and OWI third and R&O with injury. But I got to circle back to the idea that I have a defendant in the courtroom right now for a failure to appear. He hasn't posted yet. So I quite honestly, I really don't know what's going on here. I'll let you kind of hash this out, but there's one failure to appear. Chief Magistrate Klepera's right. This was a 22 incident where he got arraigned on it in May of this year, but failed to appear at the first examination. And that's where Judge Jefferson issued the 2,510%.
Fitz.
Judge, on behalf of Mr. Nelson, that's correct. Today he walked in, informed by his probation officer that he has this matter to take care of. I spoke to my client. I told him, are you aware that today, if you not have $250, there's a potential that you're going to go to custody today. He looked at me and said, I understand that. I came prepared. I came to my medication just in case that happens. He wants to resolve this matter. He has showed me proof, and I'm willing to submit that proof to this court, that on the court date of 5/23, or 5/22, when he had missed that examination, he was actually in the Henry Ford Hospital. He has provided me documentation proving that, and I would be happy to provide that to this court. He doesn't want to miss court. This seems to be a misunderstanding on his part. He was confused, and he doesn't understand which one of his cases were dismissed and which one he's still obligated to show up on. And I'm going to take care of that with him today, Judge. He did show up. He doesn't want to take care of this matter, despite the past history that he has going on. To me, he appears to be an individual committed to taking care of his matters and doesn't want to go down that road again. I would ask if you would convert this on. He will show up in court. He understands. He does not know how to use Zoom, so he'll show up in person for every hearing.
All right. Court haven't heard the arguments of counsel. The court finds that the $250 cash bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing of dangerousness to the community, complaining witness and or flight risk. The prosecutor is correct. I was a little confused. I was looking at the person on the screen thinking that's who it was, but didn't know that that was someone that had walked in on the capious bond. But okay, the court will, I guess, give some credit that he's trying to get the process, get the train back on the track. And I will take as an officer of the court that the defense is stating that they have proof in their hand that he was hospitalized on that day in question. So court is going to convert the bond to 2,500, 10%. Jeep. So he's on probation right now, correct?
Yeah, he's oh, I'm sorry.
No.
The problem that I'm having, and Judge, I think I know where you're going with this. He's on probation right now. About, the argument, I have a lot of respect for Mr. Brico, but what cases are going, what cases aren't. This is pretty clear. He's on probation and he has this case, and he was arraigned 2 weeks prior to the date he was supposed to show up for an examination. And we have a witness who showed up and he did. I mean, I need to get that out. I know you usually put tethers on individuals, and he walked in, so it makes this a little bit different, but I needed to get that off of my chest.
Understood. Understood. Yeah. Bond will be reduced to 2,500 personal GPS tether with a 10 p.m. to 6 a.m. curfew. And that's what we're doing. Thank you.
Now, Judge, I would be willing to stipulate to like 48 hours for the individual to, go get the tether. He walked himself in today to make arrangements or what have you. But, with that, I'll just stand you.
Thank you, Mr. Prosecutor. So what is today? All right. So, sir, you have till Thursday, June 19th, to go to the tether unit with the Wayne County Sheriff to get fitted for your tether. If you have not, a warrant for your arrest will issue. Do you understand that, sir?
Yes, sir.
Okay. Thank you very much.
Thanks.
All right, thank you, Judge. That was house arrest? Was that house arrest?
No.
10, I'm sorry.
Curfew
10 to 6.
10 to 6.
Okay, thank you, Chief. Just wait for your paperwork, sir.
Do you know where that location is, or?
I can tell.
Okay, and Mr. Collins, state your full name.
Purvis Tyrone Collins.
Thank you. Good afternoon, sir. This is on case 2505726. People State of Michigan is Purvis Tyrone Collins, also as Purvis Collins, Purvis Tyrone Collins. Appearances.
Thank you, Chief. As you know, always a privilege. Steve Benson, P71917.
Judge Miguel, briefing on behalf of Mr. Collins, my client can advise the constitutional rights, waives the formal reading of the complaint, stands to be requesting not guilty to the enter to do that.
Not guilty plea will enter. What are the charges and the current bond, magistrate?
The charges took place April 23rd, allegation of 2025, count 1 only, weapons, taser, possession or sale of with the habitual offender, 4th offense notice. And the current bond is 1,000 cash surety set by Judge Taylor, May 19th of 2025.
Prosecutor.
Judge, the only thing that I have to say about this, he was arraigned on the 25th, got the 5,000 personal, failed to appear at the exam about 2.5 weeks later. The same day that he was arraigned on this particular matter where he's a HAB 4th offense notice, he was arraigned on a narcotics and drug related charge that was assigned to Judge Kennedy. That had a pretrial date of May 15th of 2025, 4 days before this exam. He failed to appear at that too. So it looks like it's a pattern with this defendant. I don't know if there's any intent to come back to the 36th District Court. If it was just this case in and of itself, but looking at things in the entirety, I have, on that same day, 2 different arraignments where he failed to appear on 2 different dates. But Judge, we'll leave it up to you.
Yes.
Judge, on behalf of Mr. Collins, as current amount of bond set in the case is an unaffordable amount. I understand the cause for concern that this court may have against ways to appear. In Mr. Collins' defense, he is a lifelong resident of the state of Michigan, does have significant ties to the community, has given us an address in the city of Detroit, and she resides with a friend. And at this moment, Judge, I would be asking for an alternative measure other than monetary to assure this defendant's appearance at his next court hearing, just given the unaffordability aspect of that. Any minorization that this court may deem necessary is something that defense would have no objection to. We are primarily concerned with keeping him in pretrial detention over the monetary aspect.
Do we have any rationale for why he missed court?
Yes, he had indicated to my office, and I looked into ROA that he had showed up for court dates on 5/6 and 5/13, and I wasn't aware of the 5/18/19 dates that he missed. But Judge, to be candid with you, my ROA doesn't match a 5/6 and a 5/13 date. The only thing I can surmise is that they had filed a rescheduling date, and I think he had appeared, from what I'm understanding, to the date that was no longer calendared. So it appears he showed up to court when it was not on the calendar. There is a history of that date being changed. But the 5/6 date that he's provided from my office, to be candid, I'm not sure that may be in relation to a different case. So it's just an unawareness aspect going on there.
And Magistrate, what is the, what are the charges one more time?
Just count one, weapons possession, or sale of, with the habitual offender fourth offense notice.
Court finds that the 1,000 cash bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing of dangerousness to the community, to the complaining witness, and or flight risk. In this case, we're dealing more with flight based on the defendant not appearing at court. Bond is going to be reduced to the amount of 5,000, 10%, with a GPS tether and a 10 p.m. to 6 a.m. curfew. Thank you.
Thank you, Chief. Have a good day. Enjoy your evening.
Thank you. Everyone take care.
All right, see you, Joe.
Thank you. Mr. Collins, stay put, sir. I want to let you know you have two court dates. You have a probable cause via Zoom, June 26th, Judge Taylor. You have a right to a preliminary examination in person, July 3rd, Judge Taylor. Is that understood?
Sir.
Okay, and is that unaffordable, that 5,000, 10%?
That is, Judge.
So I'm scheduling an unaffordable bond redetermination hearing as well, Mr. Collins. And on Friday, June 20th, 2025 via Zoom in front of Chief Judge McConico. You'll attend that hearing only if you're unable to post bond, but if you're able to post, you do not need to attend that one, but always the June 26th and July 3rd. Is that understood?
Yes.
Any questions on your court dates or bond conditions, sir? You're all set. And then Mr. Nelson, come back up to the podium. Friday, June 20th. And your name again?
Boris Nelson Jr.
Thank you. And I just want to let you know, you have your two court dates, sir. Your probable cause conference is June 25th, Judge Jefferson. That's via Zoom. And you have a right to a preliminary examination July 2nd. That's in person, Judge Jefferson. Understood?
Yes, sir.
Do you have any questions on your court date or your bond condition?
Yes, sir.
All right, you'll be all set once you get your paperwork from Officer Brownlee. Good luck, sir. You're welcome. Appreciate you. Thank you. Good afternoon. Your name, please?
Darius Howard.
Good afternoon, Mr. Howard. Sir, you're here on case 25058-203, People State of Michigan versus Darius Markeith Howard, appearance for the people.
Steve Vincent, B71917.
Thank you, Mr. Ben.
Miguel Rico, 8379, on behalf of Mr. Howard, my client advises his constitutional rights, waives the former written complaint, stands mute, requests a not guilty plea be entered on his behalf.
Thank you. Good afternoon to you. So court wait formal reading under plea of not guilty. Mr. Howard, I'm scheduling two court dates. You must attend both. Probable cause scheduled via Zoom, June 24th, Judge Robbins. You have a right to a preliminary examination, July 1st, Judge Taylor. Understood, Mr. Howard?
12 and first, right?
Yep, July, thank you for paying attention. June 24th, Tuesday. That's the last Tuesday, Judge Robbins via Zoom. The first Tuesday in July is July 1st. That'd be in person, Judge Taylor. Not guilty, please enter on your behalf as the bond. Mr. Vincent.
Magistrate, it looks like he's taking this seriously already, remembering the dates. He's got one count of his CCW. It's serious but non-assaultive. At this time, we're not going to be challenging a personal bond.
Thank you.
No objection to a personal bond.
Thank you. Mr. Howard, this is a non-assaultive, very serious allegation. You have no criminal history or cases I'm aware of. After advocacy and review of the investigator's report, I'm setting bond as recommended, 5,000 personal bond. Given the nature of the allegation of illegally possessing a weapon during this bond, a condition is you are not to purchase or possess a firearm or any dangerous weapons. No weapons while on bond, understood? Do you have any questions on your court dates or bond conditions?
No, sir, but I have a question about the, something about class or something. I forgot, the name of it. It's supposed to help me out to try to, keep my license or help me out to get my license.
What's the question, counsel?
I believe, Mr. Howard, I think you're asking about like an amnesty program or something like that. Are you asking about a driver's license issue?
No, the gun license.
No, don't worry about that. You're gonna get out today on personal bond, speak to a lawyer in person at your next hearing. Don't talk about it here.
Okay.
All right.
Any questions on this case, Mr. Howard? Court date or your bond conditions? You'll be released on this matter.
No, sir, I don't. Thank you.
All right, you're all set. You're welcome, Mr. Howard. You're all set. Good luck.
All right, thank you.
Yep, you're welcome. Good afternoon. Your name, please.
Danny Spikes.
Thank you, Mr. Spikes. Mr. Spikes, you're here on case 25058-202. People State of Michigan versus Danny Spikes, parents for the people.
Mr. Coyle appearing on behalf of the people.
Thank you, Ms. Coyle.
Justice Gales, for your phone, on behalf of Mr. Spikes, my client's going to advise his constitutional rights, which stands
Thank you. Court waive formal reading under plea of not guilty. Mr. Spikes, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, June 24th, Judge Robbins, 8:30, 36th District Court. You have a right to a preliminary examination in person, July the 1st, Judge Jefferson, 8:30. Understood, Mr. Spikes? Not guilty, please enter on your behalf as the bond, Ms. Boyle.
Your Honor, people are recommending a 5,000 personal. I do not see a criminal, thus no capious history for Mr. Spikes. This was a traffic stop, not assaultive.
Thank you.
No objection from defense as to a personal bond.
Thank you both. Mr. Spikes, this is not assaultive. It is a serious felony allegation where you face up to 5 years in prison. You have no history, criminal or capious. I've reviewed the investigator's report. Being a non-assaultive allegation, I'm following both parties' recommendation. Bond will be set at 5,000 personal bond. Given the nature of allegations and what's alleged in the investigator's report, during this bond, you are not to purchase or possess a firearm or any dangerous weapons. No weapons, understood? Thank you. Do you have any questions, Mr. Spikes, on your court dates or your bond conditions? You're all set. Good luck. Good afternoon. Your name, please. Thank you, Mr. Calhoun. You're here for a couple of reasons. We'll go through them one at a time. First, you have warrants for your arrest. For failing to appear at the 36th District Court on these matters, you'll be released on a personal bond, no dollar amount. Scheduling a pretrial via Zoom, you must attend July the 1st, 9 a.m. That's via Zoom, Judge Kennedy at the 36th District Court. Understood, Mr. Calhoun? Thank you. As with any criminal matter, sir, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in the court of law. Have the right to an attorney, one present at questioning and in all future proceedings. If you cannot afford an attorney, Mr. Calhoun, the court will appoint you one at the public's expense. Did you hear and understand your rights, sir? Thank you. Mr. Calhoun, you're here on ticket numbers SP 1482913, July 27, 2023, count one, no insurance, a misdemeanor on 2020 Mitsubishi. SP 1537807, January the 4th, 2024, count two, no insurance misdemeanor on a 2020 Mitsubishi. Count three, drawable license suspended. SP 1553026, February 17th, 2024, count one, drive unregistered untitled motor vehicle. Count two, no insurance misdemeanor on a 2020 Mitsubishi. Count three, driveway license suspended. SP 1571863, April 5th, 2024, driveway license suspended. Count one, SP 1577318, April 24th, 2024, count one, driveway license suspended. Count two, no insurance misdemeanor. Count three, underage possession more than 2.5 ounces of marijuana. And a ticket SP 1687435, February 27, 2025, driveway license suspended. During this bond, Mr. Calhoun, there's to be no driving. Is that understood? No driving. These are all, thank you. No, these are all misdemeanor allegations carrying up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall those warrants, set aside capious not guilty, please entered. As a reminder, July 1st, 9 a.m. via Zoom, Judge Kennedy, you'll be released on a personal bond, no dollar amount. No driving, Mr. Calhoun. State your full name again. You have an additional felony case. And one more time, Mr. Calhoun. Thank you. Thank you, DDC. This, Mr. Calhoun's 25058-207, People State of Michigan versus Clyde Pete Calhoun, also known as Kyle Calhoun. Appearances.
Lisa Coyle appearing on behalf of the people.
Thank you.
Judge Miguel Greco on behalf of Mr. Calhoun. Judge, my client advises his constitutional rights, waives the form of the complaint, and to make respectfully request not guilty.
Thank you, sir. Court waive formal reading and plea of not guilty. Mr. Calhoun, I'm scheduling two court dates. You must attend both probable cause via Zoom, June 24th. That's at 8:30, 36th District Court, Judge Robbins. You have a right to a preliminary examination in person, July 1st, Judge Giles. That's at 8:30. Understood, Mr. Calhoun? Thank you. Not guilty, please enter on your behalf as the bond from the people.
Your Honor, I do see that this is a CCW case, a non-assaultive case. I don't see a criminal history for Mr. Calhoun. But based on, my recommendation is going to be 10% with the tether, and this is the reason for it. Here we have this case in which officers hear gunshots, see the defendant with the ski mask on his face, and this is June 14th. He runs with the they see him running with a handgun with an extended magazine. He runs into a house where a small child's at the entrance. They follow into the house. At some point, he comes out from the attic area. He comes out with no ski mask and no gun. Inside that attic, they do find that weapon. The reason that I'm pointing out that I'm asking for that 10%, not only those circumstances, which are highly unusual and very, indicative of other criminal behavior, possible criminal behavior. Back in August of last year, Mr. Calhoun, now he's not charged because the prosecutor looked at the warrant and found insufficient evidence, and they felt it was a question of self-defense. But he shot and killed somebody. There was a gunshot wound to the head. He claimed he shot back, claiming self-defense. He was 19 years old at the time. He allegedly brought that gun off the street, Your Honor. Now he is 20 years old. Within a year of this, he's got another gun back in his hand. So he's not convicted of the case. The prosecutor looked at the circumstances and they deemed that it was a question. But here now, after that, in fact, there were 3 youths involved. They were young men. And I want to say they were all under 20 years old. So young teenage men. And I believe the other 2 were shot, 1 killed. And here he has another gun in his hand, wearing a ski mask in the middle of the day or in the evening, running from the police. So I believe, based on his what's going on, and even take out the other case, these circumstances, Your Honor, I believe that he's a danger to the community armed with that weapon. So that is for that reason I'm asking for a 10% with the tether, Your Honor. Thank you.
Thank you. Thank you, Ms. Respond.
The judge, on behalf of Mr. Calhoun, I would object to any amount of monetary bond. I would request a personal bond on the matter. Judge, I would request that you don't put too much weight in the prior case in which he was not convicted of, nor did he even stand a trial for that case. I would ask us to look at the current case in which we are in front of this court for a weapons carry concealed, non-assaultive case in itself, a non-assaultive charge in itself. I understand the allegations made in the incident report that I'm not here to litigate, but it does appear that that what the police state is taken as factual, that Mr. Calhoun was entering a home which he had permission to enter. He's only charged with that CCW charge. I would ask for a personal bond on the matter. From my indication, he has no prior criminal history, no prior convictions, no pending cases, probation or parole, had 2 children, lives in the city of Detroit, is a lifelong resident of Michigan, is finishing high school online at the moment.
Thank you. All right, Mr. Calhoun, this is a concerning allegation, given what's in the investigator's report and what the information presented by the people. Your counsel's advocated well on your behalf. At this matter, this case, you're charged with a 1 count of weapon carrying concealed. I have no criminal history, assaultive or otherwise, or capious history that I'm aware of. I reviewed the investigator's report and I see the concerns as indicated by Ms. Coyle, that allegations of you, as stated, wearing a ski mask or in an area where gunshots were heard. It looks like ran into a location, fleeing, it says in hot pursuit, in an area where a young child was believed to be. Also, in the investigator's report, it states the officers were able to arrest Mr. Calhoun and recover the firearm safely with no harm coming to the children inside the location. And you have no legal age to conceal any weapon, Mr. Calhoun. Given your lack of history, and as stated by your counsel, there appears to be more what took place in this allegation. However, I don't know the legality or permission to go into this location. There's no other charges regarding entering any home without permission, nothing assaultive, no charges of firing weapons, no charges of assaulting anyone. And so given your lack of history and this charge particularly being non-assaultive, I am going to set bond as recommended by your counsel at $25,000 personal bond. Given this charge, Mr. Calhoun, you are not to purchase or possess a firearm or any dangerous weapon. You cannot possess a weapon. Is that understood? And given your age, sir, during this bond, you have no legal right to do so. Given your age, there is going to be a condition of no use of any alcohol and no illegal controlled substance. Is that understood? Mr. Calhoun, do you have any questions on your court dates or bond conditions? He's on mute. I can't hear him. Questions?
He's not on
Mr.
mute. I
Calhoun?
think he's just not close enough, Your Honor.
Okay, thank you. Speak up, Mr. Calhoun, if you have a question, please.
I don't have a question.
Okay, you're all set. Anything from people or defense? Thank you, Ms. Coyle.
Nothing further. Thank you for hearing my argument.
Go ahead. Your name, sir? Scott Corwin? Good morning, Mr. Corwin. Here for a couple of reasons. We'll go through them one at a time. Let's get your hands down by your side, please. First, we're going to handle some matters. We have a warrant for your arrest for failing to appear at the 36th District Court. On this matter, you'll be released on a personal bond, no dollar amount. Scheduling a pretrial via Zoom, you must attend July 1st, 9 a.m. Judge Kennedy at the 36th District Court. Understood?
I remember the paperwork. It's gonna be because I can't go back to my house. Yeah.
Mr. Corwin, let's slow down, sir. Listen, all I said is I'm giving you let's slow down. Just pay attention, please. On this matter, we'll handle them one at a time. This matter, I'm releasing you on a personal bond. And the court date is July 1st via Zoom, Judge Kennedy at 9 a.m. Do you understand that? Okay. As with any criminal matter, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You do have the right to an attorney when present at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights? Okay. This is in regard, Mr. Corwin, to ticket SP 1651205, December 11th, 2024, disorderly conduct near Bramwell Street in Puritan. Personal bond. This is a misdemeanor, carries up to $500 fine and or 93 days in jail is a maximum fine and penalty. Recall warrant, set aside capias, not guilty, please entered. As a reminder, July 1st, 9 a.m., Judge Kennedy via Zoom. Do you understand? Okay. You have an additional case, Mr. Corwin. State your full name again. Thank you. And this serves on case 25058-206, People State of Michigan for Scott King Corwin, also known as Scott Corwin. Appearance for the people.
Magistrate, always a pleasure. Steve Vincent for the people, P71917.
Good afternoon.
Judge Miguel Rico on behalf of Mr. Corwin, my client's been denied constitutional rights, ways of we respectfully request that this court not this behalf.
Thank you. Good afternoon. You for a waive formal reading and a plea of not guilty on this matter, Mr. Corwin. I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, June 26th, Thursday, 8:30, Judge Taylor. You have a right to a preliminary examination in person the following Thursday, July 1st. That's in person, 8:30, Judge Taylor, both at the 36th District Court. Understood, Mr. Corwin? Thank you. Not guilty, please enter on your behalf. Esteban, Mr. Vincent.
Magistrate, defendants being charged with the felonious assault as well as the domestic violence. I had to take a double take at this investigator's report because it's just kind of weird. So the defendant and the complainant, as I understand it, live together.
Yes.
And the complainant's ex-wife the defendant's ex-wife or soon to be ex-wife is the complainant's girlfriend.
Yes.
Mr. Corwin, don't talk, please.
And go figure, they get into it. And they get into an assault with one another. So, you know what? I don't have any assaultive convictions regarding this individual. Magistrate, I'm not going to object to a personal bond. I am going to be asking for a no contact whatsoever with the complainant or the address. I ended up reading both statements, defendants as well as complainant statements. They both state that they live at the Bramall address. That's why I'm asking for a no contact whatsoever with the address as well as the complaint.
Thank you. And the personal bond, no dollar amount, doesn't it?
Yeah, personal bond, whatever dollar amount.
Gotcha. Response.
Judge, Mr. Vincent's recitation of the facts are accurate as what I learned today as well. No objection to personal, no objection to alternate address, no contact. My client knows to stay somewhere else and he has somewhere else to stay.
Thank you. All right, Mr. Corwin. These are assaultive allegations. I have no history assaultive or capious less than that placed on the record. I reviewed the investigator's report. For those reasons, I do have concerns about the safety of the complaining witness. There's assaultive allegations stating that someone was hit in the head 10 times with a 4x4 plank, complaining of, I believe that was you, complaining of head injuries. The officers observed dry blood. The officers attempted to speak with the complaining witness. It looks like this was an allegation of an argument resulted in tussling and then assaults. So given your lack of history for those reasons, I'm following recommendation from both parties. You're going to be released on a $20,000 personal bond. Given the concerns regarding the safety of this complaining witness during this bond, and the assaulted nature, you're not to purchase or possess a firearm or any dangerous weapon, no weapons. You're not to go back to that Bramall Street address in Detroit till told otherwise. You have to stay away from that area. And no contact with the complaining witness, Mr. Hess, and that's no contact of any kind, orally and writing through a third party at their place of residency, employment, or through any forms of social media. No contact with the complaining witness. Is that understood? Any questions on your court dates or bond conditions? You're all set.
Judge, may I just
one second, sir? Yes.
I neglected to ask you this. May Mr. Corwin have an ability to have a third party go to the home to retrieve his belongings since he's not allowed to? They just
he can always have a third party friend or family go, but I don't want him anywhere near the area of complaining with.
Okay, thank you.
You're welcome. Juan Pickett. Good afternoon, Mr. Pickett. This is case 25058-209, People State of Michigan for Juan Morez Pickett, also known as Juan Travell Pickett. Appearances.
Thank you, Magistrate. Steve Ensign for the people.
Thank you, Mr. Benson.
Judge Miguel Brief on behalf of Mr. Pickett. My client can advise his constitutional right to waive the formal reading of the complaint. Stands mute. Respectfully request that this court enter a not guilty plea on his behalf.
Thank you, counsel. Court waive formal reading and plea of not guilty. Mr. Pickett, I'm scheduling 2 court dates. You must attend both probable cause via Zoom. Strike that, June 30th. June 30th, that's a Monday. Via Zoom, 8:30, Judge Taylor. You have a right to a preliminary examination in person the following Monday, July 7th, in person, both at 8:30, 36th District Court, Judge Taylor. Understood, Mr. Pickett? Yes? I've seen you shake your head, yes. Not guilty, please entered on your behalf as the bond from the people, Mr. Vincent.
Magistrate, as you can see, the complainant in this particular matter or named individual is a Miss Nia Johnson. Miss Nia Johnson is on our docket today because she was also arrested in this same incident because there were cross assaults.
I think we got, I'm sorry. Do we have the wrong Pickett? Are we, this is Dewan Marez Pickett.
Yes.
The allegations of resisting and obstructing, is that, I just want to make sure we're on the same.
Yeah, no, in the allegations, as you'll see, the reason why the police ended up coming and he got arrested.
Yeah. Sorry.
Yeah. No, that's okay. It took me a minute to put this all together and then to look at the history and how this all ended up developing. So we have this individual who allegedly the complaint ended up first, well, not the complaint here, Miss Johnson, calling the police because of this defendant apparently just being unruly. And then the police end up coming, not once, but twice. And then this defendant ends up getting arrested, and then he ends up resisting arrest. And then I'll get into it with Miss Johnson. Miss Johnson, this defendant ended up calling the police as well. I don't know if it was the first or second or third time. And then the police end up coming. So she gets arrested for her assault on this defendant. But the crux of this is, one, they're in a very toxic relationship. We can see that there's actually been an additional police report made against Mr. Pickett by Miss Johnson in the past for violence. But as you can see, both were assaultive. Both were acting irrationally with the police. Both needed to get clearance from the hospital for a psych before they could actually be brought to the DDC. So, Magistrate, I hope you can appreciate this. I'm not going to be objecting to a personal, but I'm going to be asking for the same thing for Mr. Pickett as I am Miss Johnson. I'm going to ask for monitorization. That's to protect both of them because they are in a very toxic relationship where now they are both calling the police on each other for assaults on each other. And then to add insult to proverbial injury, they're getting additional charges for resisting and obstructing when the police come, and they're getting arrested for the assaults that originally occurred on each other. So the people, myself representing it, just want to see separation between the two. That's why we're asking for the monitorization. We feel as though they're a danger to each other.
Well, what would your opinion be on a no contact? Because I agree with you, that's the outcome I would like to see, I believe, is what you is them staying away from each other.
Magistrate, if you're confident that a no contact will keep them separated, then you know what, I will agree with you. I just don't, reading into this and reading the history and reading all of the allegations, I don't see a no contact, them appreciating a no contact. But I understand where you're coming from because I don't have a substantial criminal history on either one of them. They're just involved in a relationship that's getting them in trouble.
Thank you, Mr. Vincent. Response.
Thank you, Judge. On behalf of Mr. Pickett, and unfortunately, this is one of the few times where I don't have as much information about the other case. In Mr. Pickett's case, what I do know is that he is charged with that resist, assault, or obstructing of a police officer, and the officers themselves are the complaining witness on the matter. I don't know what Ms. Johnson's address says because since she's not a complaining witness, it's not in my report. If I would know that, I would have asked for alternative address during intake because I am requesting the personal bond with only a no contact, no tether requirement. And I know that no contact could be hard to do if they both reside at the same address. So in the purposes of Mr. Pickett, as him being my client today, I'm asking for a personal bond, no monetization. He has no assault or criminal history as far as I'm concerned. He does work at GM. He's been there for 2 years, 5 a.m. to 3 p.m. Monday through Saturday. He has completed school up until the 12th grade. In my report, it indicates that he's the one that called the police. And when the police came, he's the one that ended up getting arrested. But in my report, it states that he was the caller. I was calling him over there because I guess some things are going on with him in a domestic part. So Judge, I am asking for this to be a personal bond. I would hate for him to be on monetization for it. I don't think he appears to be a flight risk. I believe that this court and the people's concern of protecting the people involved, whether they're named as complaint witnesses or not, is valid. I'll just ask that we do that through a no contact order rather than monetization.
Thank you both. Mr. Pickett, counsel, you have counsel has advocated well on your behalf. Both parties had arguments taken into consideration. As the people stated, Mr. Pickett, I'm unaware of any assaultive convictions or capious history. This allegation appears to have taken place and initiated upon you apparently calling the police stating that Miss Johnson had bitten you, and then when the police arrived, allegations take place of resisting and obstructing on yourself as well as behalf of Miss Johnson. Given the lack of history, my concerns, as stated, it looks like this all originated from you and Miss Johnson's relationship. And if you two were to be separated, I don't see this incident have taken place. So, Mr. Pickett, at this point in time, I think that properly protect Miss Johnson, the officers, and everyone involved would be, as stated by your counsel, for a no contact provision. For those reasons, bond is going to be set at a $15,000 personal bond. And during this bond, Mr. Pickett, you're to have no contact with Miss Johnson, and that's no contact of any kind. No contact orally and writing through a third party. Put your hand out. I'll get you. Orally and writing through a third party at her place of residency, wherever that may be, or through any forms of social media. You're to have no contact with Miss Johnson. If she attempts to contact you, you're to hang up, go the other way. If you are in contact, even if she reaches out to you, that's a violation of this bond. And that was subject to get you picked up, regardless of your guilt or innocence, and arrested, and this process started over again. So listen to the court, no contact with Miss Johnson of any kind. Do you have any questions on your court date or court dates or bond conditions?
Okay.
You say no? Okay, you're all set.
Magistrate,
Stay away from.
No contact
Go
with
ahead.
that address where it took place, correct? Because it's her, apparently it's her residence.
Yeah, so wherever her residence may be, I do not want him to go anywhere near that residency.
Maybe we just recall him the screen. I want him to be aware of that. Because,
Oh, I let him know. You can have no contact of any kind.
okay.
It would be the same thing I said. He said he had no questions. So.
Yep.
Your name, please.
Antoine Patterson Jr.
Thank you, Mr. Patterson. Good afternoon. You're here on case 2505821. People State of Michigan versus Brandon Antoine Patterson Jr. Also has Brandon Antoine Patterson Jr. appearances.
Lisa Coyle appearing on behalf of the people.
Thank you.
Miguel Rico, appearing on behalf of Mr. Patterson Jr. Judge, my client has been advised of constitutional rights, waives of formal reading of the complaint, stands due, respectfully requesting a not guilty plea be entered on his behalf as to all counts.
Court waive formal reading under a plea of not guilty. Mr. Patterson Jr., I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, June 26th. That's at 8:30 on a Thursday, 36th District Court, Judge Jacquet. You have a right to a preliminary examination in person, July 3rd. That's in person, 8:30, 36th District Court, Judge Jacquet. Did you hear and understand your 2 court date and times you must attend, Mr. Patterson?
Your Honor.
Thank you. Not guilty, please entered on your behalf. As the bond, Ms. Coyle.
Your Honor, the people in this matter are asking for a $50,000 cash surety, tether house arrest if he's able to make that bond. Mr. Patterson, my understanding is 18 years old. The complaint in this matter, Ms. Dickerson, is 17 years old. She is, at the time, was 32 weeks pregnant. The allegations are highly assaultive. Allegedly, he punched her in the face because his brother told him that the baby was not his. That's what the brother said. And that she blacked out from being punched in the face And when she came to, she ran upstairs, and then he continued to punch her in the face several more times. He then allegedly strangled her and beat her head against the wooden stairs. That she got to the point of being assaulted, that she saw fluid leaking from her vaginal area. The officers did observe her.
You went out, Ms. Coyle. Your concerns have realized. No.
Tell me when you can hear me. You can't hear
There
me.
you go. Got you.
Okay.
Yep.
I'm sorry. I apologize today. I'm.
No need to apologize.
Where did I leave off on here?
After the allegations of she could not breathe and then fluid was leaking from her vaginal
Right,
area.
from her vaginal area. Officers observed her, I believe it was her left eye that was swollen and blackened. Your Honor, this is assaulting not only a 17-year-old female, but also she's 32 weeks pregnant. So she has to be obviously close to the point of delivery with a full-term pregnancy. And he's assaulting her physically in the face as well as about the body. Your Honor, based on some allegation from his brother, whether it be true or not, this is over the top. I believe he is a danger to Ms. Dickerson as well as to the child, whether it's born or unborn at this point, that he causes a high risk to her pregnancy. So for those reasons, I'm asking for that cash surety bond, no contact, and a tether if he's able to make that bond. Thank you.
Thank you. And response, counsel, including any employment status.
Yes, Judge, on behalf of Mr. Patterson Jr., just would like to begin. Sometimes when we have these offenses, as the court, we're all aware of it, just to stay on the record, he is presumed innocent of all of these allegations unless proven guilty beyond a reasonable doubt. In addition to that, Judge, my client is 18 years old. He's a lifelong resident of the state of Michigan. He is currently employed, he's currently attending Covent House Academy and works at White Castle as well. He's working on finishing the 12th grade at the current moment. And he gets to my office that he works 50 hours per week. And Judge, just to touch base a little bit on what this court has to consider, I know it would be a disregard of me to just mention a personal bond without backing it up. I know in this situation, this court has certain considerations to make, and a personal bond may not be possible. Any amount of monetary bond would be unaffordable for my client. If this court is leaning towards a monetary bond, I would ask for it to be within reason. I would ask for a redetermination date, obviously, if it is any type of monetary bond. I believe that the greatest fear here, due to his non-assaultive history and his appearances in court, and no indication of failure to appear in court, is obviously the safety of the complaining witness and the safety of the general public. Judge, I think maybe this can get accomplished through minorization, perhaps increasing confinement with work with the people that are so inclined. I would be moving for that at this time, and leave the remainder of your discretion, Judge. I appreciate you hearing my argument.
Thank you, and I appreciate your advocacy. Mr. Patterson Jr., you've heard your counsel. He's advocated well on your behalf. And I've taken into consideration your employment status as well as schooling as it relates to ability to post bond, your lack of capious or criminal assaultive history that I'm aware of. I've heard advocacy from the people, and they bring to light the concerns that I have at the court. These allegations, Mr. Patterson Jr., are extremely assaultive, and they're assaultive on an individual that's alleged in the investigator's report you had knowledge and knew she was 32 weeks pregnant with your child. And then we have allegations of assault escalating and resulting in injury and hospitalization. As pointed out by the people, these are just allegations, but the allegations indicate that you started punching this individual in the face to a point she blacked out. Then when she came to, and it looks like attempted to flee from you caught up with her and began punching her in the face several more times. Then it proceeded an escalation of allegation of you strangling her while banging her head into a wooden staircase on the steps to a point she couldn't breathe. She had other issues with regarding the strangulation, and the officers observed injury, including a swollen black left eye when the complainant was had to be transported to Sinai Grace Hospital for treatment. Mr. Patterson Jr., coupled with the fact that this individual is alleged to have been 32 weeks pregnant with you having knowledge of it being your child, I have concerns with the escalation of assaults and that's alleged in the investigator's report, from punching to choking to chasing this individual down to banging her head on the wood to then strangling a point she couldn't breathe, blacking out. All of those give me concerns, Mr. Patterson Jr., regarding her safety. And then I do find by clear and convincing evidence you are a danger to this complaining witness, and find a personal or nominal bond will not adequately protect her safety. So I'm setting an intentional unaffordable cash bond as recommended by the people at $50,000 cash or surety with the following conditions to properly protect the complaining witness's safety. You are not to purchase or possess a firearm or any dangerous weapon. You're not to go anywhere near the Bramwell address in the city of Detroit. You're absolutely no contact with the complaining witness, and that's no contact of any kind, orally and writing through a third party at her place of residency or through any forms of social media. And to ensure that no contact, if you're able to postpone prior to being released, you'll be filled with a GPS tether with a curfew of 10 p.m. to 6 a.m. If you go anywhere near that address or that complaining witness, if you're released, that'd be a violation of this court's bond, subject to get you picked up without a warrant, have your bond conditions forfeited and or revoked. And you've indicated that's unaffordable. Based on counsel's representation, Mr. Patterson Jr., I'm setting an unaffordable bond redetermination hearing on Friday, June 20th, 2025, 9 a.m. Chief Judge McConicle. If you're unable to post this bond, you'll see the Chief Judge on Friday, June 20th, with defense counsel present. You'll have an opportunity to re-argue bond at that point. Mr. Patterson Jr., do you have any questions on your court dates or bond conditions?
No, sir, but I would like to say that I do have witnesses that happened on the
It's
situation.
not the time for it, sir. This is your attorney speaking.
This is your attorney speaking, so if you want to listen to him, go
You're
ahead.
gonna have a chance to tell your story. This is not the time to tell your story, not in front of the prosecutor, not in front of people on live Zoom. Go ahead and read the screen if you don't have any questions about your bond hearing or about your next court dates, okay? You're gonna address all that with another attorney at a later date in a confidential setting. Don't talk to anybody in the jail, on the jail phone, nobody else but your attorney, please.
Okay, and with that advice, Mr. Patterson Jr., from your counsel, do you have any questions on your court dates or bond conditions?
With bond condition,
What's your question?
they all wrote everything down.
What's that?
Your Honor, they wrote everything down for me.
Okay, no questions then?
No questions, Your Honor.
All right, Mr. Patterson Jr., listen to the court. You're welcome, thank you. Your name, sir? Thank you, Mr. Pickett. Good afternoon. Mr. Pickett, you're here on case 250-58210, People's Head Mission vs. Jalen LeMaine Pickett, also known as Jalen Pickett, Jalen Tremaine Pickett. Appearances.
Steve Vincent for the people.
Thank you.
We all agree on behalf of Mr. Pickett, Judge McClatchy advises his constitutional rights, ways of formulating complaints, and to respectfully request that this court enter a not guilty plea on his behalf as to all counts.
Thank you. Court waive formal reading under plea of not guilty. Mr. Pickett, I'm scheduling 2 court dates, sir. You must attend both probable cause via Zoom, June 27th. That's a Friday, 8:30, 36th District Court, Judge Jakay. You have a right to a preliminary examination in person, July 3rd, in person, Judge Jakay, 8:30, 36th District Court. Understood, Mr. Pickett? Thank you. Not guilty, please enter. Waive formal reading. Mr. Vincent has the final say.
Magistrate tether curfew. If this defendant had any priors, I would be asking for a cash bond. He's got a 19 FF that was dismissed, a CCW that was deferred under HIDA. So no convictions there. I do have strangulation here, which is highly assaultive. I also, magistrate, have 5 police reports made by this complainant against this defendant in the last 7 months. He recently just had a DV case that was dismissed in Judge Garrett's courtroom May 21st of this year because this complaining witness failed to appear. Again, it appears as though it's a toxic relationship. We're requesting the tether and the curfew, and because of the lack of criminal history, I'm not asking for the cash.
Thank you, Mr. Vincent. Response, sir.
Judge, no objection to the personal bond, no objection to the tether. In regards to the curfew, Judge, if this court be so inclined, just based on some of the history of my client, he's a manager at Jamaican restaurant, just worked at 11 a.m. to 10 p.m.
11 a.m. to 10 p.m. Thank you.
He gets me Monday through Saturday.
Thank you.
No problem. He does have massive medical issues that he indicated to us that he's not receiving medication for, and he may not be able to receive medication for at the jail. Judge, I would just be asking for the minorization without that curfew. He knows to not have contact. We inform anybody that's here on a domestic that they're not to have contact with their complaining witness. All cases included completely or this court orders otherwise. And I just wanted to add that the report itself does indicate strangulation, and then a little bit later on, it indicates that the complainant was not injured and refused medical attention. So it's just the complaint itself, a little bit of discrepancy. I just want to point that out. We're
Thank you, both. Mr. Pickett, this is a very serious assaultive allegation. I'm unaware that you have any assaultive history or capious history as indicated by both parties. The allegation here is that this young woman was preparing a bottle of milk for her child and you became upset, and then it escalated. You allegedly threw the bottle of baby bottle at the complaining witness, striking her, and then proceeded to strangle this young woman until she almost lost consciousness. Their allegation is no injury, no criminal history. I have concerns as I pushed close on the record. It was an argument escalated of you throwing things and then strangling to a point of almost unconsciousness. So I have concerns regarding her safety. So for that reason, given your lack of history, I'm following people's recommendation. You'll be released on a $20,000 personal bond with the following conditions, Mr. Pickett. Given an assaulted allegation, what's been placed on the record, you're not to purchase or possess a firearm or any dangerous weapon. Do not go anywhere near the Witter address in the city of Detroit. No contact with the complaining witness, Ms. Townsend. That's no contact of any kind, orally and writing through a third party at her place of residency, wherever that may be, or through any forms of social media. And given the escalation of throwing the baby bottle, striking the individual, and then allegedly strangling to a point of almost unconsciousness, in lieu of any type of monetary bond, you will be, to properly protect Ms. Townsend, you'll be through with the GPS tether, and that will place you, prior to being released, place you under curfew of 11 p.m. to 6 a.m. During those hours, you are not to leave your home for any reason unless court ordered or medical. That should give you plenty of time to get back and forth to work. If you go anywhere near the Witter address or Miss Townsend while on bond, you'll be monitored via this tether, and you would be subject to get picked up without a warrant and have your bond conditions forfeited and or revoked. Listen to the court so you don't get locked up just for not listening. You have to stay away from her and her area. No weapons. Is that all understood? Do you have any questions, Mr. Pickett, on your court dates or bond conditions? You're all set.
Thank you.
You're welcome. You're welcome. Your name? I apologize. You say Brian Oliver Jr.?
Brian James Oliver Jr.
Thank you. You're here for a couple of reasons. We'll go through one at a time. First, Mr. Oliver Jr., you have warrants for your arrest for failing to appear at the 36th District Court. You'll be released on these matters, personal bond, no dollar amount. Scheduling a pretrial via Zoom, you must attend on July 1st, 9 a.m., 36th District Court, Judge Perkins. Understood? As with any criminal matter, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have the right to an attorney at questioning and in all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights? Thank you. Mr. Oliver Jr.'s ticket number SP 1177891, March 24th, 2021. Count 1, drive while license not valid or improper license. Count 2, improper plates on an 05 Chrysler. SP 1338372, April 6, 2022. Count 2, improper plates. And SP 1491252, August 17, 2023. No insurance misdemeanor on 08 Ford. These are misdemeanors that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall warrant satisfied capious not guilty plea is entered. As a reminder, Mr. Oliver Jr., you'll have a personal bond, no dollar amount. You must show up for a pretrial via Zoom July 1st, 9 a.m. That's on a Tuesday, Judge Perkins, 36th District Court. State your full name again so you have an additional case. Thank you. And this, sir, is on case 250573343, People State of Michigan versus Brian James Oliver Jr. Appearances.
Mr. Coyle appearing on behalf of the people.
Judge Miguel Perico appearing on behalf of Mr. Oliver Jr. Judge, my client's been advised of constitutional rights, waives the full reading of the complaint, and respectfully request that this court enter a not guilty plea on his behalf as to all counts.
Thank you. Court waive formal reading and a plea of not guilty. I'm scheduling 2 court dates, Mr. Oliver. You must attend both. Probable cause scheduled via Zoom, June 26th, 8:30, 36th District Court, Judge JK. You have a right to a preliminary examination in person, July 3rd, 8:30, 36th District Court, Judge JK. Understood, Mr. Oliver Jr.? Thank you. Not guilty. Please enter it on your behalf. Ms. Coyle as the bond.
Under the people recommending a 10,000 personal bond and no contact with the complainant, Ms. Taylor, in this matter. This has a little bit of age. It's a backlog warrant back from July of 24. It wasn't signed until 25. As long as they live next door to each other. I don't know if they still do, but at the time they did. And officers did observe scratches and bruises to her. So I would ask for a no contact. He does currently have a pending CCW before Judge McCarthy in the Third Circuit. Got a pretrial on that on the 27th of this month. He's also under personal bond in that matter. So no objection to a 10,000 personal and no contact. Thank you.
Thank you.
There's no objection to the content of either of those conditions.
Thank you. Without objection, Mr. Oliver Jr., and given these assaultive allegations that noted as people stated, they took place in July of 2024, warrant not being submitted until 2025 in April. They are assaultive allegations. This is a second offense of a domestic, or you have a second offense notice, previous felony conviction, but non-assaultive. These are assault, count 2's assaultive allegation. And for those reasons, I'm going to set bond as recommended by both parties, $10,000 personal bond. Given the assaultive allegation during this bond that you're not to purchase or possess a firearm or any dangerous weapon, no weapons while on bond. You're gonna have to stay away from the Tracy Street address. Don't go anywhere near that area or premises. And no contact with the complaining witness, Ms. Taylor, while on bond. And no contact means no contact of any kind, Mr. Oliver Jr., orally in writing through a third party at her place of residency, employment, or through any forms of social media. No contact with Ms. Taylor. If you have any, you'll be released on this on a 10,000 personal bond. Any questions on your court dates or your bond conditions? You're all set, Mr. Oliver Jr. Listen to the court, sir. Good luck. Listening. Thank you. Is that all the mails?
Yes, sir. Yes, sir.
I appreciate you. We'll meet you on the female side. Thank you.
It's good seeing everyone. Mr. Reagan's gonna do the females.
I appreciate you. Have a good evening. It's good to see you too.
Thank you.
Good afternoon, Mr. Reagan.
Good afternoon, Your Honor.
Hey, Mr. Reagan.
Hey, Mr. Vince, good afternoon.
You know what I've noticed about you as the time goes on with me and you and appearing and all this stuff. You let everybody else do all the heavy lifting, and then you come in at the end, or
Well, not me.
No, we got a couple of good cases coming up. So.
Okay. The JCJ never signed in, huh?
Navarro.
Yeah.
It's gonna get rescheduled, I believe.
Okay. Magistrate, I'm just so you know, and Mr. Reagan as well. I'm just gonna ask now for the same thing that we gave on Mr. Pickett, because it's basically cross claims. I mean, I think there's an R&O they both had.
Thank you. For Ms. Johnson. Good afternoon, ma'am. State your full name, please. State your name, ma'am.
Asa Outerbridge.
Thank you. And good afternoon. You're here on case 25058-204, People State of Michigan versus Asia B. Outbridge, also known as Asia B. Outbridge. Appearances.
Good afternoon, Lisa Coyle, appearing on behalf of the people.
LeBray on behalf of Outbridge, Your Honor. For whether reading stand mute, she's been advised of arrest.
Thank you both. Court waive formal reading enter plea of not guilty. Ms. Outbridge, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, June 27th, Friday, 8:30, Judge Giles, 36th District Court. You have a right to a preliminary examination in person the following Wednesday, July 2nd, in person, 8:30, Judge Giles, 36th District Court. Understood, Ms. Outbridge?
Can you repeat the dates? You talk a little fast. I'm sorry.
No worries. Friday, June 27th, via Zoom at 8:30, Judge Giles. Preliminary examination in person, Wednesday, July 2nd, in person, 36th District Court, 8:30, Judge Giles. Understood?
Yes.
Not guilty, please enter it as the bond from the people.
Your Honor, in this matter, you hear me?
Yes, ma'am.
Okay, because everybody's frozen on my side. I'm sorry. So if you can't, please interrupt me. People are recommending a 25,000 cash surety and no driving in this matter. First, she has a 2016 interfering with the police investigation conviction. Second, at the time her driver's license was suspended from October 29th of 24 through indefinitely. She did have an intoxilizer. She had not enough to charge a .037 and an .034. The complainant's injuries in this matter were severe traumatic brain injury, and a broken pelvis. The allegations are that the defendant was driving a Jeep. The complainant in this matter was the rear seat passenger of the Civic, that's Ms. O'Neill, and that the Honda had the green light. There was a car stopped at the red light, and Ms. Outerbridge's Jeep went left of center and entered the intersection on the red and then hit the Honda. That impact then pushed the Honda into a utility pole. The speed limit is 30 miles an hour on Schaefer there. The speed of the Jeep at 1 second before the crash was 64 miles an hour without any evidence of braking. We also had that at the hospital, when she is taken to the hospital, she pulls away from the officers and tries to run into a bathroom. And that she also attempted to bite one of the officers, and she's caught on video saying, I did try to bite him. That's the R&O on this matter, Your Honor. And so based on these allegations, she's a danger to the community, based on her driving on a suspended license. She does reckless driving. She actually pulls left of center, hits a vehicle, goes through a red, and critically injures somebody and changes the course of the rest of their life, allegedly. So for those reasons, the people believe she is a danger to the community. And even though she didn't have a driver's license, she felt empowered to get into a car and not only drive, but drive recklessly and not drive like for those reasons, I'm asking for that 25,000 cash surety, the condition of no driving, and if the court sees necessary, a tether. Thank you.
Thank you. Response.
Thank you, Judge. Judge, we see it as so completely different than Ms. Coyle. Judge, this was an accident. This was simply an accident. My client's going to through a yellow light, and the light had not yet turned red yet. Now, there's going to be some arguments about that, maybe. My client says there's a video of her going through the yellow light. You know, I don't by any way, shape, or believe, I don't know if this was what was said, that a car was turning, making a turn. I don't know if I'm accurate in this, turning at 65 miles an hour. I think that's virtually impossible. Now, if we're talking about going straight down the street, then you know, that may be different, Judge, going through a light. I don't know. I just know that my client says this was an accident. She even asked if it was possible to send flowers, something to the person. She never knew the person's name that was in the hospital. My client had to go to the hospital. She was in a traumatic state of mind. Officers were grabbing at her. she was freaked out, Judge, according to her words. Those are her words. And a firefighter was able to take her in. They recognized her, officers recognized her. She said, started to call her the peanut butter and jelly girl from some type of tick video that they recognized her for, started making fun of her. It freaked her out even more, Judge. And this is what she's telling me. I'm not making this up, Judge. So it's a lot more than what we actually see in a report that officers may write sometimes. It goes deeper than that. She was traumatized by this too, Judge. It wasn't intentional. She said she was going through a yellow light. She feels as bad as anybody about this woman, Judge. You know, understandably, she's driving, as Ms. Coyle did say, without a valid license, which is something that nobody should do. But I don't think that a $25,000 cash bond for somebody in this situation, Judge, is amenable. So I would ask the court for no driving without a valid license, a personal bond. Let this case matriculate through the trial process, and let's see what happens. Let's see what evidence the people come up with, what the defense comes up with, and let's just see how this case matriculates. I don't think an arraignment, a cash bond is necessary, Judge. Thank you.
Thank you, counsel. And Ms. Albridge, you have good counsel, as you've heard, advocate well on your behalf. And I agree with everything Mr. Reagan said. However, he didn't address my major concern of you of driving and allegedly driving, knowing that your license has been suspended and still getting on the road. And then that allegation of that decision that you make of driving without the legal right to drive, you alleged to have caused an accident and severely critically injuring this complaining witness with brain injury, broken pelvis, have been transferred to and treating at the hospital, Sinai Grace Hospital. This could have all allegations been prevented had you listened and followed the law initially, as alleged, and not drove any vehicle unless you had the legal right to do so. You don't have a right to drive. That's a privilege, Ms. Albridge, and you have no right to be on the road. And it looks like your license is suspended for a reason. You have a number of outstanding, or you have a number of violations. I see in the investigator's report, and you have an indefinite suspension since October of 29th of 2024. So those are my concerns. You apparently don't listen. You drive unsuspended, so you by statute you were supposed to be notified of that. And you're on the road regardless, apparently, and causing these injuries. You have no history, criminal or cases that I'm aware of, so I think I can properly protect the safety of the public. Like I said, I agree with what Mr. Reagan said. It looks like an accident, but it could have been prevented had you had not been on the road to begin with. So for those reasons, a bond is going to be set at a $100,000 personal bond. There's to be no driving, period, whatsoever, no driving. And also to ensure that you don't drive, since I'm not convinced that you listen, before you're released, I'm going to fit you with the GPS tether, placing you under house arrest. So no driving, and you're not to leave your home. And that's in lieu of the cash bond as recommended by the people. I think that if you listen to those conditions, that will properly protect the safety of the complaining witness. And also, given the allegations of the minor alcohol, I'm going to impose during this bond, no alcohol use or possession, no possession or use of any illegal controlled substance, and no contact with the complaining witness, Mr. O'Neill, O'Neill, and no contact of any kind, orally and writing, through a third party at their place of residency, employment, or through any forms of social media. You're not to contact the complaining witness in any way. And again, you will be under house arrest before you go with the GPS tether before release. Do you have any questions, Ms. Outbridge, on your court dates or bond conditions?
About the bond and am I able to go to work?
No, you're going to be under house arrest till told otherwise by a judge. You're not to leave till any reason, and no driving whatsoever. Any other questions on your court date or bond conditions? Anything from people or defense?
Nothing further. Thank you.
No, Your Honor, thank you.
You're welcome. You're all set, Ms. Albridge. Your name, please.
Brittany House.
Thank you, Ms. Howe. Ma'am, you're here on case 250-58091. People State of Michigan versus Brittany Nicole Howe, identifying the place defendant 2, also known as Brittany N. Howe. Appearances.
Thank you, Magistrate. Steve Benson, P 71917.
Thank
Your
you.
Honor,
sir.
we're bringing on behalf of Ms. Howes, waive the formal reading stand mute. She's been advised of her rights.
Thank you, sir. Court waive formal reading and her plea of not guilty. Ms. Howell, I'm scheduling 2 court dates. You must attend both. Probable cause scheduled via Zoom, June 27th, 8:30, Judge Giles, 36th District Court. You have a right to a preliminary examination in person, July 2nd, in person, 8:30, Judge Giles, 36th District Court. Understood, Ms. Howell?
Yes, sir.
Not guilty, please enter on your behalf as the bond, Mr. Benson.
Magistrate, I'm asking 10,000 cash surety tether curfew. I looked in the register of actions. Defendant 1, Mr. Woods, was charged with the home invasion first, in addition to the FAFF 2 counts. He was arraigned by the Honorable Magistrate H. Artea June 8th, 9 days ago. She ended up issuing a $35,000 cash surety bond tether house arrest. That went up to redetermination June 11th. The Honorable Chief Judge McConico continued the $35,000 cash surety tether house arrest. This defendant is not being charged with the gun charges, but she is being charged with the home invasion first degree. My reading of the allegations, as well as apparently this was on video and we have the complaining witness here, this individual broke into this house first. This individual ended up attempting to try to assault the homeowner. This individual was helping ransack the house, as well as take that individual's belongings. So we do feel as though this defendant is a danger. I don't have any priors for this individual, candidly, but we do feel as though based on these allegations and the charge, she is a danger. Respectfully asking for that cash with monitorization.
Thank you. Response, including employment status, Mr.
Just briefly, Your Honor, my client, Judge, Mr. Vincent said, Judge, that never had a ticket. But this is a situation, and I talked to her about the co-defendant and how you can put yourself in certain situations that are bad for you. She's at a location, Judge, and she gets into a fight with the complaining witness. The fight starts outside. It starts outside, and we talked about this with the other defendant. And the fight escalates, and the girls are fighting, and they roll into the front door, and they roll into the house. And that's how my client gets in the house. She never breaks in the house or tries to ransack anything. But the way in which people describe it on the other end, and I understand, Judge, it's 2 sides. There's no video of my client ransacking anything and breaking in and kicking it. I'm pretty confident in that, Judge. Obviously, I wasn't there, Judge, so I don't want to say what happened. But I get that side of the story with my client. But not charged, as Mr. Vincent said, with any gun, anything like that. She's simply charged with the home invasion, which we're going to show that it wasn't a home invasion at all. It was just simply a fight that kind of rolled into the house, Judge. So what I'm asking the court to do is set a personal bond for her. Obviously, she doesn't want to have contact with this girl. I think the co-defendant knows the girl, and there was some type of beef between Ms. Howes, and they started arguing, and it turned into a fight, and it rolled into the house. But I don't think my client is going to have any contact with her, wants to have any contact with her, or go near her. So I'm asking the court in this case, Judge, it's a little different than the other defendant, for a personal bond, Judge.
Thank you. Thank you. As Mr. Vincent pointed out, it is different because Ms. Howes is being charged with count 1, the home invasion first degree, not the possession of the weapons, not the felonious assault, but it's a very serious 20-year felony. And it is indicated that defendant 2, Ms. Howes, was the one who ran in first. And it's indicated started assaulting the complainant. However, there's no charges regarding that. I reviewed the investigator's report. I've heard advocacy from both parties. Ms. Howes, your counsel has always did a good job advocating on your behalf.
Because I apologize. She did turn herself in. I forgot to say that she walked into the precinct today to surrender herself as well. And I apologize for interrupting.
No, thank you for that. That's important to the court, Ms. Howes, and that also, and that's considered that you surrendered yourself to the court to address this allegation. And given your lack of history, lack of criminal or capious assault or otherwise, my concerns are regarding the safety of complaining witness as well as you returning to the location. So in lieu of a cash bond, I am going to set bond for those reasons at a 50,000 personal bond with the following conditions. Given your lack of history, during this bond and given the assault of allegations, you're not to purchase or possess a firearm or any dangerous weapon. You're not to go back to the Mendota address in Detroit. Have to stay away from the complaining witness, Miss Resende. No contact with Miss Resende is no contact of any kind, orally and writing, through a third party at her place of residency, employment, or through any forms of social media. And given the allegations that you were the first to run into this home uninvited and an assault took place, and the concerns I have regarding the safety as complaining witness, before being released, you will be fit with the GPS tether with a curfew of 10 p.m. to 6 a.m. During those hours, you're not to leave for any reason unless court ordered. If you go anywhere near the complaining witness or her address, you will be monitored via tether. That was subject to get you picked up without a warrant and have your bond conditions forfeited and or revoked. Do you have any questions on your court date or your bond conditions, Ms. House? Any questions? Okay, anything from people or defense?
No, nothing further.
No, Judge, thank you.
All right, thank you both. You're all set, Ms. House.
Your Honor, I'm gonna sign off because my computer's still acting up and I'm finished. So
Yeah, go give it a
Okay.
rest.
have a good day, everybody.
Go give
Sorry
that
about
computer
that.
a rest.
All right.
All right, have a good night. Your name, please? Thank you. This is case 250-58208, People State of Michigan versus Nia Tanisha Johnson, appearances.
Steve Vincent for the people.
We'll bring it on
Thank
behalf of Johnson, Your Honor, waive the reading stand mute. She's been advised of her rights.
Thank you. Court waive formal reading under plea of not guilty. Ms. Johnson, I'm scheduling 2 court dates. You must attend both probable cause via Zoom on Wednesday, June 25th, 8:30, Judge Jefferson. You have a right to a preliminary examination in person the following Wednesday, July 2nd, 8:30, Judge Jefferson, both at the 36th District Court. Understood, Ms. Johnson? Say yes, not guilty. Please enter waive formal reading as to bond, Mr. Vincent.
Magistrate, it's just a situation that just went too far. As you know, Mr. Pickett was also being charged with counts. I believe it was an R and O. They apparently reside together, toxic relationship, taking the words from defendant's mouth that he uses, but I believe it's applicable to this particular matter. Now, to this defendant's credit, she actually has contacted the police previously and made a report against Mr. Pickett in the past, but here we have her as a defendant. So respectfully, we're going to ask for the same bond that you ended up giving to Mr. Pickett. I believe that's her residence. So just a no contact with Mr. Pickett. I guess it's just competing no contacts between her and Mr. Pickett.
Thank you, Mr. Vincent. Any objection, Mr. Reagan?
Judge, I apologize. I didn't hear what the first bond was from Mr. Pickett, but if it's personal.
15,000 personal.
No objection, Judge, no objection.
All right, Ms. Johnson, this is an allegation concerning, you have no criminal history, assault or otherwise, no CAPUS history. After review of the investigator's report, no, you're good. I've heard advocacy from both parties. I agree with the people, as stated on the previous matter, the Mr. Pickett's matter that we just arraigned this afternoon, that this appears to be a relationship that needs some separation, and that were the case, this allegation apparently may not have taken place. So for those reasons, your lack of history, I'm releasing you on a $15,000 personal bond. But given those concerns during this bond, you're to have absolutely no contact with Dwayne Pickett, and that's no contact while on bond of any kind. No contact orally and writing through a third party at his place of residency, wherever that may be, or through any forms of social media. No contact with Mr. Pickett. Is that understood? Okay. If he reaches out to you, don't answer, stay away. I don't want you to get locked up for not listening. Do you have any questions on your court dates or bond conditions? No? Anything further from people or defense?
No, thank you.
No, Your Honor, thank you.
Right. DDC, do you have any males or females that you're aware of at 48 hours that cannot wait till tomorrow morning? I appreciate you. Thank you and your staff as always. I hope everybody has a good evening and be safe, everybody.
All
Thanks,
right,
everyone.
thanks, Chief. See you,
Thank
Phil.
you,
The defendants are lucky to have you guys. All right, see you later.
Thank you. Appreciate you, Steve.